Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Hello. So I have this matter down today for a hearing on damages as to Mr. Johnson's default and as to Marlin's Plumbing's default. And then I separately was contacted by Miss Teasley about a discovery dispute that she had indicated uh, Cool Runnings is having, who is the one third party defendant that is not in default, and that matter is heading toward trial. And there is apparently some discovery dispute that Miss Teasley wanted to see if I could address today as well. Mr. Koblitz, am I going to hear from you on behalf of Brixell?
Yes, Your Honor.
And did I
I'm here
say your
for you.
name right?
Yes, you did. Thank you.
Oh, excellent. Okay, gold star for me. Good start. And so were you aware of that discovery issue and would you be able and prepared to understand I typically conduct my discovery as a conference. It's very informal. The purpose is simply to try and work that issue out. Is that something that you'd be able to talk through today if we take it up?
Yes, I think there's a preliminary question first, though. At the pretrial conference on May 7th, the court had stricken the answer of Cool Running. I know Miss Teasley had sent an email regarding the non-appearance and requesting that that be withdrawn or changed. I know that we were instructed to submit a proposed order striking that, which we did. I don't know whether the court ever signed or entered that order, and I
No,
don't know whether the court ever responded to Ms. Teasley's inquiry by email.
right. So I
And
don't
that was my
have.
concern is that I never received an order. So,
Okay. Yeah. And so I actually drafted an order today. I don't, if you did send an order, I never saw it. It sometimes, as you might imagine, we receive a lot of email, but you are correct that the ruling at the pretrial conference that occurred on May the 5th was that or May the 7th, perhaps, but it was that first week of May, was that the parties who were not there, that their answers would be stricken. And forgive me, Miss Teasley, because you had continued to be in touch with the court. I was not aware that you had not, I had forgotten that you had not appeared. So that is entirely my fault. And again, I have no record. I did instruct y'all to submit an order, but I have no record that an order was submitted. And in fact, today, when I was preparing for the hearing, what I was doing was going back through my notes saying, oh, Mr. Johnson did not appear at the pretrial conference. And so I had ordered his answer stricken and had prepared an order to that effect that I was going to file today. Um, and so that's sort of where we are. And I don't know what, Ms. Teasley, I have not yet entered that order. It would be entered today, and it would, if Mr. Koblitz's recollection is correct, it would also apply to your client. And so what would you have me do in that regard, Miss Teasley?
so I do acknowledge that I was not at the hearing.
Mhm.
And that was an oversight on my part. Um, but our conversation prior to my conversation with Attorney Ackland was that we were trying to, because of I didn't realize I wasn't made aware of the disbarment of Mr. Johnson's attorney. So when we discussed that, we discussed dismissing our claims. So I assumed that we were going to talk about that. Like I said, the hearing slipped my mind, and then things started moving in motion. So I
Okay.
wasn't. And then when the order never got signed or never saw an order, then I assumed that you had decided that you weren't going to sign the order. But that was where I was.
No, that doesn't mean that you did not send it. It's entirely probably my oversight, but I don't have a record that I ever received a proposed order striking the answer. We're pretty quick about entering those. So procedurally, where that leaves us, Mr. Koblitz, is that currently Ms. Teasley's client is not in default because Ms. Teasley's client filed a timely answer to the third party response, and I have not yet stricken her answer by order. Now, Mr. Koblitz is right. I did announce that my intention to do so, but that order has not been entered. Mr. Johnson, I think, is in somewhat of a different position because the operative complaint the operative answer that he filed that would have been struck or that I have drafted an order striking it was untimely and he was technically in default anyway. And the effort by, I did see that Mr. Johnson filed a motion to open default, but that motion is insufficient procedurally and the costs have not been paid to open that default. And so there wouldn't be a basis to open default. Regardless, we've lost Mr. Johnson. I don't know if that was intentional or technological, but why don't we do this? Mr. Koblitz, have you had a chance to talk with Ms. Teasley about this issue?
I have not yet. I do see the emails today briefly between Mr. Yacklin and Ms. Teasley.
Okay, why
And I
not?
do.
I'm sorry to interrupt. What I was going to say is if y'all haven't had a chance to chat, why don't you do this? Well, I'm going to wait maybe 5 minutes or so and see if Mr. Johnson rejoins us or if that was maybe intentionally him saying bye when he heard me say he was in default. Why don't you guys go into a breakout room and chat? Well, there's Mr. Johnson, but I still think it would make sense for the two of y'all to go into a breakout room and chat and see what you want me to do in that regard. Okay.
I
Okay.
mean, and before we do, I can also proffer. I mean, my understanding is the only reason that we have not responded to the discovery request is that we were under the impression the answer had been stricken.
Yes.
I think upon a quick conference with Ms. Teasley, if the answer is not stricken, and upon a quick conference with Ms. Teasley, either outside of this or now, if you prefer, we can come up with an extension deadline that would make sense. I don't think we're going to dispute that we should respond to the discovery if the answer stands.
Okay. Well, and really the part I was thinking y'all should talk about is what is Brickcell's position going to be on Miss Teasley's clients, whether the answer should be stricken or not. Given that, as I said, procedurally, I did say that was what was going to happen. That is my standard procedure, but I did not enter an order. And so right now the options are Brickcell can take the position that no, you should have entered the order when we sent it to you. That was the oral pronouncement you made. We want you to go ahead and enter that order. Ms. Teasley can act in whatever manner she chooses to if I do that. Or you can say, it's fine, we'll proceed and let Ms. Teasley go forward without the stricken answer. So that's sort of the position that I was looking for y'all to discuss.
Okay. Yeah, we can do a breakout room and discuss
Okay.
that if you prefer, Your Honor.
Mr. Freehoff, can you place Ms. Teasley and Mr. Koblitz in a breakout room just for maybe 5 minutes? And then I'm going to take a break for about 5 minutes and I'll be back with everyone when Ms. Teasley and Mr. Koblitz rejoin.
think the judge is out for a minute, so.
Well, we are back if everyone else is ready, but on everyone else's time or on court's
Bradley,
time.
can you call me, please? On my
Sure.
cell phone, please, thank you.
Yes, Mr. Koblitz?
Yes, we did just have the meeting. I think I actually might need another 5 or 10 more minutes, so I'm very sorry.
No, it's
Uh,
fine. I mean,
yeah.
this is probably not what you anticipated walking into. I will say that I have gone back and reviewed my email that we received closer in time to the hearing.
Mhm.
And if it helps your assessment, I will note that um, back near the time of the hearing, Mr. Yaklin noted that let me see. Mr. Yaklin, and I think you were copied on it in May of 20, May 21st. He said that, his position was that Ms. Teasley was aware of the hearing and he was expecting her to appear because there'd been some communication, but that Mr. Yaklin had stated he did not have opposition to Ms. Teasley's request that the court not execute the proposed order to strike Cool Runnings' answer. So I just thought that might be helpful. I didn't know if you had that at the ready, but that might be one more piece of information to inform you. But it is 1:50. Why don't we take a break until maybe 2 and come back? Okay.
That should be enough time. Thank you for the information, Your Honor.
We're in recess until 2. Thank you.
Thank you.
Okay. Thank you all for joining us. Mr. Koblitz and Ms. Teasley, did y'all have a chance to coordinate and decide what we're doing?
Yes, we did. I am proposing that I will withdraw my motion to compel.
Mm-hmm.
Um, if the court agrees to not sign off on the default order for Cool Runnings. And then
Okay.
we're going to resolve any issues we have about any outstanding discovery.
Mr. Koblitz, that's your position is that Brickell is not going to pursue the default as to Cool Runnings, or but more importantly, I guess, to pursue a striking of their answer based on their failure to appear.
No, we do not oppose the court allowing that.
Okay. Okay, so then that actually takes care of the issue for today between Cool Runnings and Mist and Brickell. And what that leaves is the issues associated with Marlin's General Plumbing and Mr. Johnson. So just to sort of for Mr. Johnson's benefit, because I have received some messages. Mr. Johnson, these are private messages that were only sent directly to me, and that's called ex parte communication. And so I just want to make sure you understand that I'm aware that those messages have come through, but I've not looked at them substantively and will not consider them because you didn't copy Mr. Koblitz, who is opposing counsel, and Ms. Teasley on them. But you will have an opportunity to be heard before I take any action in this case. That's what the hearing is for. By way of background, I do want to just sort of set the stage. So the record indicates that Marlin's Plumbing has actually been in default since April of 2025. Now, I guess in the interest of being fully, clear, it looks like there was the default judgment was entered as to Marlin's again in July of 2026. But my record indicates that Marlin's is in default. The only open issue was that the damages against Marlin's were unliquidated. And so there needed to be an evidentiary hearing so that Brickell could prove up or offer evidence of the asserted damages. Now, as to Mr. Johnson, I see that you have now sent messages. And so let me see if I can sort of summarize the position, Mr. Johnson, that you are in. So the record indicates that you were served with this lawsuit back in, I want to say November of 2024. And you filed a motion to dismiss, asserting that service was not proper. The court didn't actually rule on that motion because Mr. Yacklin appeared at the hearing and said, look, we want to be cautious, and so we're going to undertake to get service in a different manner. And so permission was sought and given to serve Mr. Johnson, to serve you by publication. And that service was accomplished in, order of service in April of 2025. The time for an answer would have been in no later than June the 16th of 2025. And you did not file an answer on or before that date. So that meant that under Georgia law, by operation of Georgia law, you were in default at that point. Now, there is a procedure under 91155 to open default, but that has not occurred in this case. And so, as far as the court is aware, Mr. Johnson continues to be in default. There is the added component that even if that answer had been timely, Mr. Johnson did not appear at the pretrial conference, although I'd probably be willing to, I would be somewhat forgiving of that simply because of the fact that I believe Mr. Johnson was represented at various points, perhaps by Mr. Mzikawe, who has now been disbarred. But that's the position that you're in now, Mr. Johnson, is that to the extent you filed an answer in June of 2025 that is not otherwise subject to be stricken, it was a late answer. And as I said, there is a procedure by which you can seek to open default, but you did not follow that procedure in the year since then. And so the purpose of today's hearing was for Mr. Koblitz to present testimony or evidence as to the damages, which I believe are similar. I think that there is also a claim for attorney's fees as to Mr. Johnson, but the damages asserted as to Marlin's Plumbing were for the breach of contract claim and the negligent construction claim. Is that correct, Mr. Koblitz?
That is correct.
Okay. And so I would assume it's the same type of evidence. And what I was expecting was that there would be some presentation of evidence on the issue of damages today.
So for Marlin, yes,
Okay.
because we did have the judgment against Marlins already in setting the hearings. We were not actually anticipating presenting damages as to Johnson today. From our view, that made more sense to present with the damages against Boy Wonder once those proceedings took place. But similarly to the plaintiff Boy Wonder, similarly to the issue with the Cool
The
Running, there was no
plaintiff Boy
order
Wonder-
actually striking
hang
their
on.
complaint yet. Sorry.
Granted, this case has gotten messy because of people not appearing. The case was dismissed at one point, then it was reinstated at the request of Mr. Mzikawe. Now he's been dismissed. But last I checked, Boy Wonder is no longer a party to this action.
And do we not have, and if I'm misremembering, I sincerely apologize, but I thought we had counterclaims directly against Boy Wonder as
Okay.
well, Bristol.
Okay. If you have a counterclaim, then yes. I
And
thought
let
you were
me-
referring to their original claim.
No, Your Honor. And let me confirm that for you because I do not want to misstate that if that is not the truth, but that is my recollection. Yes, and counterclaims. Yes. Okay. Thought I was crazy for
Okay.
a second. Apologies, Your Honor. Yes, we do have counterclaims. And those claims are much more closely tied to the damages against Mr. Johnson. And frankly, it's a much larger volume of evidence and a larger amount of damages.
Okay.
And we were only just ordered to file a motion for default judgment against Mr. Johnson earlier this July. We have not had the time yet to prepare that evidence yet, but we are ready to proceed with damages against Marlin's Plumbing.
Okay.
And
So,
if Your Honor we would also request an order for default judgment as to liability and then that a hearing be set, which I believe is in the contents of the proposed order that we submitted to you on July 31st.
okay. So, okay. So, Mr. Johnson, for your benefit, here's what that all means. For a couple of things. Number one, what Mr. Koblitz is requesting today is that the court enter an order of default against you, right? Which is essentially just an order that says you didn't file a timely answer, and so you're in default. And then that order would set a hearing for a later date for the presentation of damages, evidence regarding the alleged damages that resulted from the claims for breach of contract, negligent construction, and attorney's fees and expenses that are sought by Brickell against you and against Boy Wonder. I suspect, as Mr. Koblitz pointed out, that if this matter is set for trial or some sort of final hearing relative to Cool Runnings and Boy Wonder, that the caliber of your damages would likely be resolved at that time, assuming that you remain in default. But as I said, there is a procedure. I can't give you legal advice, but there is a procedure by which you can seek to have your default opened or to set a default aside, but you have not followed that procedure. Now, what Mr. Koblitz is suggesting is that I enter an order of default, and then you could take whatever legal action you would like to take, Mr. Johnson, to ask the court to reconsider that or to move to set it aside or open it pursuant to Georgia law, and the court would take that up at the appropriate time. I would not enter a final judgment against you today because Mr. Koblitz has not asked for one, and they are not prepared to present evidence regarding your default. Do you understand? I know you probably disagree with it, Mr. Johnson, but do you understand what I've outlined for you from a legal perspective? Mr. Johnson?
Able to hear me?
Yes, I can.
Okay. I understand. I believe I understand that they are a judgment on Craig Jackson, not Boy Wonder at the time. And it is up to me to, if I wanted to follow the procedures to open the default, to it. So if you do grant their request, then it's up to me to, I guess, file an answer or deal with trial, when it, am I understanding that correctly?
Well, you're breaking up a little bit, and I'm only hearing a little bit of what you're saying, but I think it sounds like you are understanding. What I was saying is that what I would do is enter a judgment. I would enter an order today, finding you in default. And then, but it would not be a default judgment because there's no evidence in front of me as to the amount of any judgment that the court would enter. And that likely would not be resolved until the court takes up the more substantive claims relative to Cool Runnings and relative to Boy Wonder. But for now, what would happen is the court would enter an order finding you in default, and then you could undertake whatever efforts to set that aside or ask the court to reconsider it in line with Georgia law that you choose to do so. Does that make sense?
Yes.
Okay.
Yes.
I'm sorry, did you have something else you wanted to say, Mr. Johnson?
No, I said yes. I
Okay.
understood what you said.
Okay. So with that, then Mr. Koblitz, that was a long way of getting to where we started out at the beginning to be. But if you wanted to, I did receive your proposed order as to Marlin's Plumbing. If you wanted to, and I also received a series of emails from you with exhibits attached. If you wanted to provide that evidence, and do you intend to call a witness, or what? How would you plan to present that information? You're muted, Mr. Koblitz.
Yes, I was. Thank you. Yes, Representative from Brixel, Miss Gabriela Padone, is on the
Okay.
Zoom call now, and she will be testifying to Brixel's damages against Marlins.
Okay, Ms. Padone, will you unmute and raise your right hand, please?
Yes.
Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. You may lower your hand. Go ahead, Mr. Koblitz.
Thank you. And Your Honor, can I request that the court take judicial notice of exhibits, I believe it's A through R, submitted this morning at around 9:10 a.m. to the court?
Yes,
Okay.
I do
And
have them available, and I am able to review them while you are presenting.
Okay. And with respect to, there are several business records in here that would qualify for the business records exception. Is that something that you could allow as part of judicial notice, or alternatively maybe allow me to give one general statement that these are business or qualify these and lay foundation that these are business records as a whole, as opposed to doing it for each of the 16 exhibits?
I'm definitely in favor of efficiency, sir. So yes,
Fantastic,
assuming that
Your
it
Honor.
is the same or substantially similar foundation that you need to lay, you're free to do it in that manner altogether.
Great. Yeah, I've got like 2 or 3 categories generally. I think it'll work perfectly. But all right, thank you. Wrong thing. Oh. All right. Could you please state your name for the record, please?
Yes, Gabrielle Padone,
Okay. And who do you work for, Ms. Padone?
Brixwell Investment Group.
And how long have you worked for?
I believe since 2020, 2021.
Okay. And what's your role there generally?
I am the CEO.
Okay. And what was your role in relation to the project and contract at issue for this case?
Well, initially I was just supposed to be hands off, but I ended up having to be hands on the day-to-day of the construction and trying to find trades and managing the funds since the work was mostly not done properly.
Okay. And are you able to speak from your personal knowledge about the events in this case?
Yes.
And then specifically, do you have personal knowledge of the exhibits today submitted as A through R to the court?
Yes, I do.
Okay. And do you have those exhibits with you?
I do.
Okay, great. First, we'll look at exhibits A, B, and C.
Okay.
as well as F, H, and I. And I'll give you a chance to look at those individually to make sure you recognize them, each one in a second. But at first, so starting with A, do you recognize Exhibit A?
Yes, I do.
And are those invoices and receipts related to the project?
Yes, they are.
Okay. And is the keeping of invoices and receipts in this form, is that a standard business practice for Brixel?
Yes, it's a normal scope of business.
Okay. And it does that in the in its regular practice?
Yes,
And copies of those records are made at or near the time that those records are received or kept?
that's correct. Yes.
All right. And they're made by people with personal knowledge related to those invoices and receipts?
Yes.
And as well with the estimate that is Exhibit H?
Yes.
Okay. And I want you to just look at first at Exhibit A and just tell me, do you recognize it?
Yes, I do.
And is it part of the business records of the invoices and receipts?
Yes.
Okay. And then same for Exhibit B.
Yes.
Okay. And then for Exhibit C?
Yes. Also.
And then for F?
Yes.
And one more, and for H as well. I know you just said it.
Yes.
And then lastly for I.
Yes.
All right. The third-party plaintiff Brixel moves to admit Exhibits A to C, F, H, and I.
Go ahead. They're admitted.
Thank you. Now looking at Exhibits J through L.
Okay.
Looking at those exhibits, first, do you recognize J?
Yes,
And you recognize K
I do.
and L?
Yes.
Okay. Oh, and then also, sorry, and then O.
Let me pull it up.
And I know once we get through this, it'll get much easier, I promise.
Yes.
Okay, you said yes. And then P,
Yes.
and then Q,
Yes.
and then R.
Yes.
And generally, those exhibits you just looked at, what do they show?
Invoices and paid invoices for work that was supposed to be done for the project.
Okay, and so to be clear, these are records of Brixel's payments for the invoices that we just talked about in A to C, F, H, and I.
That's correct.
Okay. And then I actually just, so let's look at M real quick. Do you recognize M?
Yes,
And that's one of the invoices that should have been in the first category.
that's correct.
Okay. And these records are similarly kept in the course of Brixel's regular practice of business,
Yes,
and it's standard for them to do so.
it is.
Okay. And they're made at or time, at or near the time that they were collected and recorded by people with knowledge of them.
Yes.
And some of these records were actually collected by you yourself, correct?
Yes.
Great. All right. And the Brixel will move to admit exhibits J through L, M, O, and P to R.
Go ahead. They're admitted.
Thank you. And last but not least, exhibits D, G, and N. And do you recognize exhibits D, G, and N?
Yes, I do.
And what are they generally?
They're messages that were kept regarding the project and payments and
And
work.
specifically, these messages are related to payments for plumbing work done by Marlins,
Yes, that's correct.
and they were sent and received in the regular course of business.
Yes.
And then the records of them were kept in the regular course of Brixel's business.
Yes, they were.
And is it the regular practice of Brixel to keep texts like these that would reflect interactions with clients and business partners?
Yes.
All right. The third-party plaintiff Brixel moves to admit exhibits D, G, and N.
Go ahead. They're admitted.
Thank you. So tell me about the basis of how Brixel and Marlins got involved.
Marlin Plumbing was recommended by Boy Wonder and Craig Johnson to do the work for the plumbing for the home at 1597 Metropolitan Parkway.
Okay. And with respect to that work, how was it completed? Was it completed first? Was it fully completed?
It was not.
Okay. The work that was done, were there any issues with that work?
There were a lot of issues throughout the years with the work that was done with the plumbing and then with the work that was outlined in the invoice that would be done. And it wasn't done by the plumber, by this plumber Marlin. So we had to outsource and get other people to fix the issues. There were several leaks throughout the years because of the improper installation of these plumbing pipes and bulbs and whatnot. And so either Mr. Johnson was going to fix it or we'd have another trade vendor to fix the issues that were ongoing due to Marlin's plumbing.
Okay. So those repairs that were needed by Marlins, either bad or missing work, Brixel either did pay for them or will be required to pay for them.
So we paid the Marlin's plumber in full, and for things that he didn't complete or didn't complete properly, he didn't come back to fix the issues. So we had to get other people to fix the plumbing issues and the drywall and whatever damages stemmed through the negligent installation.
So I guess we'll start kind of timeline wise at the beginning when kind of first things started to go wrong. And I understand that there may have been something occurring in February of 2022 when issues began. And so with respect to that, I'll ask you to look at Exhibit A for me, please.
Yes.
And so what happened on February 22nd, 2022? How were you damaged by Marlins then?
We had to order another like steel shower mechanism for something that wasn't installed properly or wasn't ordered properly. And then the next itemized invoice is basically the work that Marlin would do for the installation of the plumbing. And then from then on, there's other receipts that show either we selected other trades, vendors to come fix issues for work that he refused to do or work that wasn't done properly.
Okay. And so specifically for the shower, how much did that cost?
So for the
For
shower,
Brixel to repair?
to repair the shower or the just that little piece.
Or sorry, I should rephrase it. How much did Brixel pay Marlins for that?
$140.35, and that was for that we had to get this material. That wasn't for like the installation or anything. It was
Okay,
just a piece that we had
understood.
to get.
But it resulted in $140.35 cost to Brixel?
Correct.
Okay. And then with respect to the installation of the plumbing and the gas lines and the additional plumbing, how much did that cost Brixel?
So the initial installation that we paid for to Marlin was let me check, $19,094.27.
Okay, great. And then with respect to the receipt from the amount taken from electrical to pay the plumber invoice, how much did that cost Brixel?
So let me see. That was an additional $5,950.
Okay. And then for the repairs that were needed to fix the plumbing installation in the crawl space and the plumbing holes that's also shown on Exhibit A, how much did that cost Brixel?
That would have been well, there's two of them. There's the $11,685.44, and then there was another invoice for $18,120.70.
And that 18,000 reflects the updated amount, the combination of the 7,000 and the 11,000 number. Is that right?
No, this is a different and separate. This is an invoice 1907. It's a different invoice that we had to pay to Boy Wonder. It's not cumulative. It's a different invoice.
Okay. And then what does that invoice show with respect to damages caused by Marlins?
So it's for drywall, repair, plumbing leak. So it's basically a double charge that we had to pay, Boy Wonder, and then we essentially had to pay them again, L&L Services for the same work because it wasn't completed.
Okay, so then was the total damage for that one 11,685 and 44 cents?
Yes.
Okay. Sorry about confusing you there. That's on me. All right, and so then around that same time, we're going to quickly look at Exhibit F. And what does Exhibit F show us?
Exhibit F is just a receipt for additional valves that we had to get. The ones that were installed were not correct for the showers. So we had to repurchase additional valves that would be, so we could properly get those installed, those showers, and avoid any more leaks in the walls.
Okay. Thank you. All right, and now we're going to look at, for this one, Exhibit I and Exhibit K. If I have this right. Yes. Now, can you explain? There was a question of an initial payment to Boy Wonder with the drywall and that. So can we talk a little more about the double charge with this?
Okay.
Yeah.
Katie,
Sorry, what was that?
Sorry, someone was calling in while I'm in the hearing. I apologize, Your Honor. With respect to Exhibits I and K, there appears to be an issue of double payment. Can you explain that for the court? Looking at I first. I know K just shows the charges that Brixel made, but with respect to I, can you clarify the double charge and how much is actually owed?
Yeah, so for the L services, they actually are the contractors who completed the drywall and fixing all the leaks and repairs. And so I is from L&L Services, $11,450, and then $9,000, another one for $9,000.
Okay. And now let's look back at, let's look at I, keep looking at I. See a charge there from June 2nd, 2022.
Yes.
And what's that for and what's the amount?
So I is for 9,000, and it's for like painting over, to have to paint and fix the drywall.
And what damaged the drywall?
The leaks from some of the showers. Essentially, all of the 4.5 showers have had leaks and issues with the pipes.
Okay, and then 6 days later on June 8th, there's an $11,450 payment on that same Exhibit I. Were those related to the same damages?
I'm sorry. Hold on one second.
Yeah, take your time. And I may be total.
Okay, so we're on Exhibit I now again. Sorry, it just closed down.
Yeah, no, of course, take your time.
Okay. So what page are you looking at?
No, if I had page numbers, that would have been very convenient. And oh, that's why. So we're looking generally at all of these charges. I may just have a mistake on mine. Okay, on June 8th was Brixel required to pay $11,450 to further repair the drywall from the plumbing leaks in all the bathrooms.
Yes.
Now let's take a look at Exhibit B.
Okay.
So what are the damages reflected in Exhibit B?
So the damages Exhibit B are the upstairs, like the ceilings and the walls. It's not all of them, but it's some of them that were affected by the leak behind, I guess, behind the shower.
Okay. And how much, looking through these charges and each one, can you just share with the court how much each piece of work cost and to Brixel based on Marlon's faulty or incomplete work?
So let me see this one. So it was an invoice for $9,591.75, $3,200, and another one for $6,819.
Okay. And reflections of Brixel's payments for those are in Exhibit K, right?
Some of them, yes. And all of these invoices were paid. So the invoices for L and L services were directly paid to L and L
Okay.
because
And you have personal knowledge that those were paid.
yeah, because we had already paid for everything again to Boy Wonder and Craig Johnson, and so the money in those accounts weren't being distributed to L and L, so we specifically distributed the payments to L and L to make sure the payments are going directly to the trade.
Okay. And then, so later on, then in August of 2022, there was some paint labor required, I believe is spelled out in Exhibit K.
Yeah, so June on July 13th, there was paint that was required for the $3,777.75. And then August 26th was $3,100 of just paint labor only, not materials.
So that first 37,775, that is from Exhibit B, right?
Correct.
Okay. And then the 3,100 is in Exhibit K and then also reflected in Exhibit L.
Yes, that's correct.
There was all, now let's look at Exhibit L, pull that up.
Okay, give me 1 second.
And for this one, we're looking at the first page of Exhibit L.
Okay. Okay.
So what is that payment on the first page of Exhibit L? What is that for?
Let's see. This one it's for an invoice for $3,858.40. It's invoice 1922 for $1,000. That was a payment made for that invoice.
And that invoice was related to plumbing work done by Marlins.
Yes.
Mr. Koblitz, I just need to turn my camera off for a moment. I am still listening, I promise. I just didn't want you to be surprised and think you had to stop. Sorry for the interruption.
Yeah, thank you for letting me know, Your Honor. And while we're on L, we'll go ahead and also look. I'll find it. Okay, no, that's fine. Later in December, related to L and L, was there another installation with floating vanities that needed to be made?
Yeah, so before the floating vanities needed to be made, there were pipes that were protruding from underneath the sink and the walls that needed to be moved over, that were not properly affixed or installed.
Okay, and just because we're on Exhibit L now, was the charge for that was $720 as shown in Exhibit L?
Let's see. That was partial, a partial charge for that.
Okay, so we'll see the rest of that charge carried out in. So another payment for that was $3,720. Is that right?
That's correct.
Okay, and that's reflected in Exhibits J and L.
Yes.
Okay. So now let's look at Exhibit G. And we're going to look at this for context. And maybe you can use this to add some context into what we've been talking about. And if there's anything that speaks to anything we haven't talked about yet, you can provide that as well for the court.
Okay. 1 second. Okay, so Exhibit G was sent to, when I was finally given the contact information to Marlon Alexander, I sent him like a formal demand to please either come fix the work or return the money that was paid. His basically the message says that he was paid in full a while back, and there's since had done the work, there had been severe flooding, damages to the floor, flooring underneath the floor, floorboards, the drywall, the tile, and much more. And he didn't, he refused to complete the work or remedy the work. I gave him an opportunity to come back and try to fix it, and then he just never responded. I let him know that like some of the civil penalties and violations according to the code, as well as vandalism. There was another time where he came in and just like made holes randomly in the walls and didn't come back to fix it. And I sent him a text on March 29th, also letting him know, please either I demand full payment or come here, please, and remedy the work that you've done. But I never received a response. And then there's some more text messages between Craig Johnson, Craig Miller, and I about like relocating the pipes that need to be moved in order for the vanities to be installed. The plumber, then Marlon decided to show up, and then when he did show up, the property said he can't install the vanities, so have Danny do it, which is the L&L services. So essentially, Danny had to redo everything and install the vanities.
Okay, and now let's also pull up Exhibit D. We're just gonna go through all the text now and just get all the context out. I should have started with this.
Okay. Okay, Exhibit D is just another issue with a leak. There were like 6 or 7 leaks. And there's a text to Craig Johnson and Craig Miller. We have a group chat about the plumbing, and I asked if there's plumbing directly underneath the back porch ceiling, which was one of the master bedrooms. And so there was flooding and water coming down from there. And I asked if there's plumbing directly underneath here. He said, I believe so. And that's when I like contacted him and said, I'm getting worried about the plumbing issues. I think what needs to be done regarding the vanities, everything has been installed improperly. We need to move the plumbing in Master 2 over to the right. I sent a couple pictures of this 2 months ago. You said your plumber would address it, but he has not. And obviously, as a result, there was a bunch of further leaks. Master 1 and the Master 1 plumbing wall, the pipes were protruding out of the wall. I also had sent a picture 2 months before that for the plumber to fix, but he never came to fix it. And then he said it's not something he's going to fix. So I asked, well, what is he allowed to do, or what can he do? It doesn't make sense that he can't do anything that we're asking him to do to come remedy the installation or the poor work that he had done.
Okay.
There was another occasion where they said that the pipes burst due to freezing weather, but I had another plumber come in and he said that they did not burst, and there was no evidence of that. It's just faulty installation, so he had to fix that.
Okay. And then for the text messages, at least, last but not least, let's go to Exhibit N.
Oh, and sorry, and there was another text message within the exhibit where some of the money from electrical was moved for the plumber for him to come back to fix the work, but then the plumber didn't come back to fix the work. And Craig Johnson said that he would fix it, but he didn't come out to fix it. And so that's when I noticed that a lot of the invoices that were already paid in full, the money was taken out of those invoices. So then I received those invoices again saying that I needed to pay them in full, that the whole balance was due.
Okay. And that was kind of what you were mentioning earlier with the invoices that were from electrical transferred to, okay.
Yeah, so I reached out
Correct.
to Craig Johnson and asked him like, well, you need to have these things fixed because the plumber that you recommended is not coming back, is not answering my calls. Then he said he would come fix it. He didn't, so I had to have someone else come fix it, fix everything. And meanwhile, there's another text in here. This is about a generator that we had, but it's not related to the plumbing, I guess.
Okay. So anything else from G that you think is important towards the damages from Marlins to Brixel?
Just that I would, let Mr. Johnson know about these issues, and he said he would pass on his sentiments to the plumber and go from there. And then it was radio silence. And then there's another message where he said, well, he's not going to come out until I'm paid for a certain invoice.
Okay. And then for context, going back to earlier, the text messages in, I believe it was Exhibit D, showed that Marlins had been paid,
Yeah, Marlon had been
at least
paid.
according to those texts.
Yes.
Okay. All right, then now let's look at Exhibit N.
Give me 1 second. Let me pull that up. Did you say M or N?
N. N is in no. An answer I hope I don't hear. I'm kidding.
Okay. Got it.
And what are we looking at here at N?
These are also other text messages between Craig Johnson, Craig Miller, and I. Um,
How do they relate specifically to the damages caused by Marlins Plumbing?
so let me see. Give me 1 moment.
Yeah. And I apologize for not letting you do this before we started looking at a bunch of receipts and invoices. This probably would have helped tremendously with context.
Okay, thank you. This is basically a text to Craig saying, you know what, I thought all of the things that were listed for the plumber to do were supposed to be from the original invoice, and they were not done. And so they continued to add more things and said, oh, well, this is not part of it. And this is not part of it either. So you're going to have to pay another invoice to get this done. So I thought the original invoice included the plumbing and gas lines specifically. And I had let them know that I think all of these things fall under the plumbing work and gas lines in addition to the installation of the plumbing work for the connection for the fixtures. I didn't know that it was going to be a separate thing for me to have Danny from L&L do this, and I have to pay for this twice. Let's see. And I let him know that obviously Craig Miller and I are not the professionals here, so we don't know the ins and out of everything regarding the completion of the work. But when you provide an itemized list of things that need to be done, it's under the impression that we already paid for them, so they should have either been completed properly or remedied. And then there's a couple other messages that just basically says that Craig Johnson's like, I'm not going to come back until you pay all these invoices. I'm not going to fix the plumbing. And we basically said, well, all of these trades have already paid for in full. So we would like you to come out and fix these things, but they weren't fixed. We were kind of forced to pay another invoice for other work up front, and the work wasn't done. And we had to essentially have Danny finish it from L&L Services.
Okay. Thank you for that. And now as we continue, I won't go back over the ones we've already been through, but as we continue to go through, I hope that helps assist you in refreshing your memory on some of this stuff. I know it's a lot of numbers, so thank you for bearing with me. So then I guess on the similar note, we're still talking now about the issues with, or what ended up going to L&L LLC. You had just talked about patching repairs with like walls in the dents, and that was a $3,720 invoice as seen in J&L. On that same, it seems like in that same kind of vein, in Exhibit I, there are some costs associated with fixing additional plumbing leak. Can you tell us something about that? I think it starts around page 15 of Exhibit I.
Okay, 1 second. Okay, page 8 just shows the receipt that we paid the $11,350.
Okay.
On page 8. Okay,
Looking at to go towards around page 15.
Okay. Page
And I
9,
believe
there's a payment also to L&L Services for $1,655.67. And then there's, let's see, let's go to page 15. The payment for $9,400. And 1 second.
And I'm looking specifically at the $2,880 charge on, I believe, is the 15th page of Exhibit I.
Oh, okay. Exhibit I was sorry. Yeah. Give me 1 second.
Okay.
I'm not seeing that charge on page 15.
Yes, of Exhibit I. Are we looking at the same one?
I'm looking at Exhibit I, payments, PDF. Give me 1 second. Sorry about
Yeah,
that.
take your time. And it's invoice 092-01147. So 1147 are the last four digits.
$11.47. And that was for 2,000. 1 second.
2,880.
Okay, yes.
Okay, what was this charge for?
That was again for repairs for leaks. I don't remember exactly which bathroom it was, but all the bathrooms essentially suffered leaks a couple times.
All right, then now we'll look at similar, still on this last one, I believe, on this L&L issue, Exhibit K.
Mhm. Pull that up.
And help you find it in advance. But the question is going to be, do the repairs made to there's a, there was a, if there was a master grade tile issue, what were the damages associated with that? The
Yeah, so
master bedroom with the grade tile.
that's the master on the right side of the house with the tub. There was a leak in the shower and the tub faucet, which went underneath and then it went down to the first floor.
Okay. And does Exhibit K show that Brixel paid $2,695 to fix that?
Yes.
All right, let's look at Exhibit M. This will be an easier one. Talk to me about Exhibit M.
Okay, let me pull that up. So Exhibit M is for a recent leak for the same like plumbing issues. And so the tub from upstairs, the faucet, there was a gasket that's missing. It wasn't installed properly. And so it caused water to like come back up from the faucet and it went seep down all the way to the first floor and it caused severe water flooding. The whole entire ceiling had to be stripped out. The cabinets had to be stripped out. The floors had to be stripped out. Like the whole first floor was gutted out because of this.
Okay, and what was the total cost of Brixel?
For just the cabinet removal, trying to salvage some of them, it was $10,789. And $32,501 to like fix the drywall, fix the plumbing and the floors. All the floors had to completely be stripped out. Insulation had to be taken out. And even the insulation down at the crawl space.
And if we look at Exhibit H, what do we see regarding that $31,000 charge?
So
Right.
that's basically an outline of like all the things that needed to be repaired,
Okay.
like broken down by line items.
Perfect. Okay. Now let's pull up Exhibit C.
Give me one moment. Okay, I got it.
All right. And tell me about what we're looking at here.
So this part is for the installation of like the cabinets and the LVP flooring. It doesn't have the materials in there either, but it's what was paid for that, $2,713.
Okay, and then are there other charges reflected in Exhibit C?
Yeah,
Scrolling down further to the bottom.
yeah, for the kitchen island, to have to repair the kitchen island. Let's see. Um, yeah, so kitchen island, the LVP flooring, the floorboards, that was another $8,599.44.
Okay.
There had to be like floorboards. The floorboards also got like soaked with water. Um, it was just like drenched with water that had come down, so that all had to be removed and replaced.
Okay. And I was going to ask you about. And then there were also, was there also a $4,709 charge in addition to that associated with the repair and damage from these specific leaks by Marlins?
4,357.38, I believe, or $4,709.
Okay, yes. And now let's take a look at the repair estimate that is Exhibit H.
Okay.
We are down to less than 10 numbers to go for everyone's convenience and knowledge.
Okay, I'm there.
All right. Talk to me about this estimate and the damages to Brixel related to it.
Yeah, so that's the estimate that I was talking about, not this before when you asked me the first time about the 32,000. It's for the demolition. Everything had to be demoed, so completely gutted. So this is for the gutting work and for the removal of the cabinets, the drying had to be dried out. And yeah, basically for those repairs.
Okay. All right. Let's look at Exhibit I.
Okay.
And you know what? I actually might just have the exhibit number wrong on this one. So here, from recollection, do you remember there were, if I represent to you that there was a $13,400 charge and a $23,618 charge related to sealing, back deck repairs, other things caused by plumbing leaks. I thought it was in Exhibit I, and I might be mistaken, and that's completely on me. I apologize for that. Do you recall from it whether, where those are reflected in the exhibits we're looking at today?
Yeah, so though, I mean, I need to double check where they are reflected, but that's in regards to invoice 1861 for 13,400 and invoice 1669, March 26, 2022 for the $23,618.40. That's for the repairs for the leaks that were coming from the ceiling from the bathroom, and that was part of the text messaging, and I think Exhibit D or G, where I took a picture of the ceiling from the outside patio. It was completely, all the water was coming down, and that comes from master two. Those were the leaks coming from the second master.
Okay, perfect. Thank you. Now, similar question, but with respect to there was an installation of new doors related to L&L and invoice 092011134 that also I thought would be in Exhibit I, but I'm not seeing it now. It is actually. Aha, page 19
Okay.
of Exhibit I. If we could look at that. Talk to me about that.
So there was I haven't seen, sorry, page 19. I think our numbers are off on what I'm looking at.
Okay, maybe try 20 then. Maybe it's the page off because the exhibit page at the top. Or the page before or the page after.
Is it it's $9,400?
I was looking at the 9,990 and 50 cents. Maybe we're looking at a different one when we're saying I. Because it seems like there's been a little bit of confusion between us when we looked at I. So I just want to make sure we get that cleared up.
Give me 1 second. Let me open up this other document that I have. Okay, HI. I'm sorry. Can you tell me the page number again? I just opened up a different PDF.
Okay, yeah, maybe this will be the same one that we're looking at. Okay, so this is 21 of 23.
Okay, so exhibit. So for exhibit I, we have the um, invoice for the 1861 for the $12,482.43. And then invoice 1869 for $9,525.16.
Okay, and what are those for?
And those, I believe, are for the repair from the flood from the ceiling, from the patio, the door window installation, and some of the material for the repairs.
Okay. And then there was a fairly large sum owed based on additional electrical work that needed to be done in April of 2022. Um, can you tell me some about that?
April of 2022. Let's see.
It's April 20th, 2022.
Oh, yeah.
Should be the date.
So that is under, let's see, there was additional electrical work that had to be done because of like the water damage. So the invoice will reflect the electrical invoice as well as funds that were taken from the escrow account that we had already paid in full. So instead of paying I don't know, I guess instead of paying the plumber from that invoice, he took it from the electrical invoice. And so we then we were left owing now the electrical invoice, and the electrician was not going to come back until that was paid in full.
And so
So that,
that was a direct result of Marlin's.
yeah, and so that kind of correlates with the messages in the exhibits, I think DG, and I can't remember the other one where the text messages
And
kind of show going back and forth saying, well, these trades have already been, the invoices have already been paid in full, and some of these are just sitting in escrow, but we need it to be applied to the correct, trade.
okay. And how much was that invoice for?
So this last invoice was $9,525.
Okay, related to the additional electrical work that needed to be done in April.
Yeah, that was, let me look at this document.
How much did Brixel pay for that? And it may be a combination of some invoices, but if you know
Yeah,
from your knowledge.
it's $24,687.
And that's reflected throughout the payments and everything that we see in exhibits A through R.
Correct.
Okay. And all right, only two more numbers, everyone. Now we're looking at exhibit L.
Okay. Give me one moment.
Yes. I don't think we've looked at this one yet, so take your time. No, we have.
So there's also the one for I think invoice 1907, and that was, let's see, two. Okay, we talked about that actually. The invoice 1907 for the $18,920.
Yeah, so what I'm looking for here, so there were some payments to a man named Gus. Is that right?
Oh yeah, so those payments were made for so during the leak for I think December 28th, um, when Craig Johnson had said, well, it's probably freezing pipes because of the weather, but it wasn't cold during those times. So I had to hire Gus to come take a look to see what the leaks were and if the pipes in fact did burst, and it wasn't a result of freezing pipes.
Forgive me, just to clarify, Ms. Padone, was this a different occasion than the one you'd already testified about before?
So this is one of the occasions that I testified regarding the December 28 text messages.
Mhm.
Craig Johnson and Craig Miller and I. And so when we hired Gus was to come check everything out immediately because I wanted to mitigate the damages to not cause even more water issues. So
Okay.
that inspection where he came out.
Okay, thank you.
And then so okay, so that includes the failed inspections, failed inspection fees. And what was the total cost to Brixel based on that?
So for Gus, when he came out on that occasion was $400. Then it was another three payments of $1,000 that we had to pay as a result of those like leaks and having people to come in, failing inspection fees. We had to have the inspector come out several times throughout the process for just the plumbing alone.
Okay.
But for
Now I
Gus
know,
come out and give us his opinion as to where the leak was coming from and investigate the leak.
okay. So now kind of summarizing everything, we've looked at a lot of documents and exhibits and everything so far. So I just want to make sure, in totaling and in calculating the total of Brixel's damages, inclusive of all of these invoices, receipts, and payment records, did you make sure to exclude any overlap so that there were not any double charges or multiple requests for money?
Yeah, so this would
Okay.
just be in relation to the plumbing installation, the plumbing leaks, having to repair all that stuff. And some of the materials, I didn't include the cost for materials or the taxes charged or the interest and the credit cards that we had to use because it was just kind of impossible to go back and try to trace everything, especially in some of the invoices that where the money was allocated and taken out.
Okay, so the total number that you're requesting today is actually lower than what your real damages are caused by Marlins?
That's correct.
Okay, and what is that number that you're requesting today based on all of the evidence we've discussed and everything that Marlins did to cause Brixel damages?
It's 252,605 and 58 cents.
Okay, and you're not seeking attorney's fees anymore, right? Against Marlins?
Um, I mean, if I can get attorney's fees, I would like to get attorney's fees.
Well, the question, and Mr. Koblitz, you can clarify it, but the question is whether or not the complaint sought attorney's fees against Marlins. And if it did, then you would need to discuss with your attorney whether and how you wish to try and recover those. So assuming that you requested them, that's something that you would need to discuss with your attorney. If you did not request them, then at this point, there would not be a basis for you to recover them against Marlins. Mr. Koblitz?
Okay. I'll just go ahead and I'm going to withdraw that question just for the
Okay.
sake of cleaning up the record and
Sure.
Ms. Padone, with respect to anything else related to the evidence we've discussed, if you think there's anything else the court should know about the damages caused by Marlins or the amount of damages owed by Marlins, please share that, or otherwise you can say no.
Not at this time, Your Honor. Thank you.
All right. The third-party plaintiff, Brixel, rests.
Okay. So given that Marlins is not here and is already defaulted, I don't believe there's a basis for anyone. I mean, I don't believe there's any other issue. There is not a request for recovery of attorney's fees, and no one else here has an interest in vindicating the rights of Marlins Plumbing. And so, as I've previously indicated, Marlins Plumbing is in default. Brickell Investment Group is entitled to a final default judgment against Marlins Plumbing. And what that means is that the well-pleaded factual allegations of the complaint, specifically the causes of action by Brickell against Marlins Plumbing for negligent construction and for breach of contract, are deemed admitted, and therefore Brickell is entitled to a judgment against Marlins Plumbing for breach of contract and a judgment against Marlins Plumbing for negligent construction. The only question I have, Mr. Koblitz, is to the extent that it needs to be reduced to judgment, is the amount sought one, are the damages, I guess, are you going to pick a horse to ride? Are you picking the breach of contract horse? Are you picking the negligent construction horse? Because you can't recover a judgment on both, or you can't enforce a judgment on both. You could probably get a judgment on both. What are your thoughts on that, sir?
I would to point out for it. I mean, I'd like the judgment on both. We would probably only enforce it on negligent construction if Your Honor prefers to that the order
I
be
don't
tailored
have,
to only.
yeah, I don't have a dog in that fight. And so
Okay.
my
I think the
ruling,
proposed-
that's okay. My ruling is going to be that you're entitled to a judgment on both causes of action. But I just want to be clear that you can't, just because I'm about to enter a default judgment on the cause of action for breach of contract in the total amount of 200 and whatever $1,000, and for negligent construction in that amount, you can't recover $600,000. Just want to be clear on that.
Thank you. I would never dream of
I know you
violating
wouldn't, but
the economic loss rule is rings clear in my head. We deal with a lot of negligent construction. I completely understand now, Your Honor. Thank you. Yes, we will not do that.
Okay. And so what I have written down, the final number that Ms. Padone testified to is $252,605 and some change. Did I write that down correctly? And what is the
58
dollar
cents,
amount
right.
of the cents?
Sorry?
252,605.
58 cents. And I'm
58.
checking now just to double check that our proposed order that we submitted is that amount. We submitted another one yesterday with an updated amount that wasn't just requesting a hearing. And I want to make sure that that's correct for you, Your Honor. Okay, so yes, I will send you immediately after this an updated proposed order with the slightly increased amount that we are requesting from what I wrote to you yesterday.
Okay. Well, I already have your judgment, and just so you understand, the order that you have sent, I had already edited it primarily because I've already entered an order of default as to Marlins Plumbing. In fact, I entered it twice, so it's really entered.
Okay.
But so the proposed judgment, the proposed order that you sent over, what it will be called is a final default judgment. And the way I have edited it, what it currently says is the court previously entered default judgment or default as to liability against Marlins Plumbing. The court held a hearing on August the 6th and heard testimony. And based on the testimony, the court finds damages in the amount of blank and therefore enters final default judgment in favor of and against blah in the amount of. So
Okay.
if you are confident that the number is the 252,605.58, I feel comfortable that we can enter the final judgment that you are seeking.
Oh, thank you, Your Honor. That'd be perfect. Yes, that's our number.
Okay. Anything else that you need from me, Mr. Koblitz?
Yes, I would like to ask about the striking of the Boy Wonder complaint. Last time we spoke about it, I had asked if you wanted us to submit a proposed order, and I believe that you'd stated then the court would enter one of its standard or on its own accord. But we haven't seen that order yet, striking Boy Wonder's complaint. We would, either request that happen or offer to submit a proposed order to that effect.
So, hang on just one second, because I had reviewed the file in this case for this. Let me make sure I can pull it up real quickly. Hang on. And I believe what happened is that a very long time ago, the court dismissed Boy Wonder's claim. And in fact, the clerk actually misunderstood the dismissal as being a dismissal of the entire case. And I had to enter an amended order that clarified that the court had only dismissed Boy Wonder's claim and not any counterclaims that were still pending. I don't know the extent to which the parties are able to view in order the way that I can, because I have docket entries.
What do you have it at? That's how we organize our files similarly. What number do you have that as?
I am looking for it just now.
Could it be 46? No.
So 76 on April the 18th of 2025 was the amended final order dismissing the case without prejudice as to plaintiff's claims, which was at the time Boy Wonder.
Seeing first amended scheduling order. I don't see that one in our. You said 76? Oh, amended order. Okay. We have that as 70.
So that does not, I mean, of course, Boy Wonder
Okay.
cannot be in default on the counterclaims because they aren't required to file an answer.
Right. Right, of
So
course.
we will figure that out when we get to it, but I believe that document would set to rest your concern about the continued pendency of Boy Wonder's claims.
Okay. And then the last but not least, then I think earlier I might have either misspoke or wasn't clear when I was speaking about Mr. Johnson's our request with Mr. Johnson, and he's still here. I don't want to
He is still here.
proceed. Okay, good. All right. I didn't want to say anything without him being present. We would still request that an evidentiary hearing be set as we asked for in our proposed order and our motion to go ahead and proceed with those. We don't know how long it'll take to get to a trial with Boy Wonder, or just generally the rest of the case overall now with Ms. Teasley and with Cool Running now being back in the game. So we would like to proceed with an evidentiary hearing against Mr. Johnson on the court's next calendar that's available.
Okay. Well, I will do that. As I said, I'm going to enter an order, as I mentioned earlier, Mr. Johnson, that reflects that Mr. Johnson is in default as to liability, subject to a hearing on damages. And to be clear, Mr. Koblitz, the options I gave you were if they are if they're so intertwined with the claim of proof as to Boy Wonder, then we could do it as part of the trial. But if not, you can have an evidentiary hearing. I suspect that what I will do is set that hearing for either probably 60 days from now to give Mr. Johnson time to take any action he'd like to take relative to my entry of that default. And then you and Ms. Teasley will have had an opportunity to advance your discovery efforts because I mean, not for nothing, but this is the oldest case on my docket. I mean, except like maybe some random quiet title from forever ago. But because this case has had so many procedural hiccups, it is very old, and I would very much like for it to move toward completion. So I certainly understand that, and that is what I will do. After we deal with Mr. Johnson's position in the case, which, depending on what he files, depending on the outcome of an evidentiary hearing, then the next thing that will happen will be a direction toward Cool Runnings and Boy Wonder litigating those claims to the extent the parties are not able to resolve them. Okay?
Okay, great. Yeah, as long as, I appreciate you reaffirming your options, and yeah, just reaffirm that we are electing the option of proceeding on a hearing against Mr. Johnson as quickly as the court will allow. We're also in the same line of wanting to get this done as fast as possible.
Okay. Ms. Teasley, do you have any questions for me about, I think that your conversations with Mr. Koblitz resolved the issue of the discovery matter that you had raised. Your client continues in its position in the case, and so you guys can engage in discovery. Mr. Koblitz had indicated he didn't have any problem providing discovery responses. And so then likely what would happen is I would not see you guys again for, like I said, about 60 days. At which point we will be dealing with the claims as to Mr. Johnson, and then from there figure out what to do in terms of scheduling trial, et cetera, for Boy Wonder and Cool Runnings. Any questions from
Yeah.
there, Ms. Teasley?
No, I don't have any, and I didn't actually file the motion with like e-file, so I'm just gonna there's nothing to withdraw. I just
Okay.
mailed it to Mr. Mitch, yeah,
Koblenz.
Frohoff,
Yeah.
yeah. So yes, so
Oh, to
that's all
Ms.
I
Freehoff.
did.
And also
Yes,
understand that not for nothing, but my standing case management order says don't file a motion to compel until you say, hey, judge, we have a discovery dispute. So that
yes,
way
yeah,
you don't have to waste your time and your client's money filing or preparing
right,
that motion when really the answer is going to be, Mr. Koblitz, why haven't you answered discovery? I think you should answer discovery. And then that'll be
right,
the end of it.
right.
Mr. Johnson, I know that you, Mr. Johnson, are you there? Okay, well, if Mr. Johnson, I'm going to adjourn this meeting. If Mr. Johnson is still with me, I may take a brief moment to say to him the same thing I've said to each of you, which is that we will set a hearing in 60 days. Otherwise, I will provide notice of that hearing. I do believe that Mr. Johnson indicated in one of the emails where he did copy everyone, that he has now opted into the e-filing system. So we should not have any issues with him getting notice of proceedings going forward. Okay.
Okay.
Okay. Thank you all very much. Have a good day.
Thank you, Your Honor. Have a
Thank
good
you, Your
day.
Honor.
Bye-bye.
Bye-bye.
Okay. And counsel, for those of you who are here for the I hope one of you is going to give me a good shorthand way to refer to the name of the plaintiff. Um, the ICAFS Inc. versus KP Painting. For those of you who are here for that matter, I went a little bit long about other matter, but if you could give me about 5 minutes to just sort of reset before we begin with that matter, I would appreciate it.
Yes, Your Honor.
Excellent. Thank you all. I'll be back with you in just, it's 3:19. I'll be back by 3:25. Thank you.
Christina?
Hi, Ty. How are you?
Good. Just saying hello. I think this is going to be pretty short. Evan and I have been talking and negotiating for the better part of the day. So
That's
um,
good.
we've got an agreement, not an agreement on the case, but an agreement on how to proceed with these motions.
We had a few discussions.
Now, Lori, are you my court reporter? I believe she's my court reporter.
Suspect she's
here.
doing-
I'm here. I'm here,
Okay.
Mr. Brown. I'm Brown. I heard you call on my name. I was like, oh, oh. I'm here. Yes,
Well,
I'm
thank
the
you
court
for
reporter.
doing this on short notice.
Oh, you're welcome. You're very welcome.
Christina, while we're waiting, I did tell Evan earlier today that I would like to take there's two depositions. Other than Sean Gray, there's only two other depositions I think I would like to take. Number one is a corporate representative for the plaintiffs, possibly. I just have never had a case in which I didn't do one of those. But that's a possible. But the main other deposition that I want to take is a corporate representative of Azalea Park Apartments. So we'll be working on that.
Good afternoon. Thank you for that brief chance to sort of reset my brain so that I could give you my undivided attention. Good afternoon, Ms. Roy. How are you?
Good, how are you?
Doing well, thank you.
Good.
I am going to go ahead and call this case for Ms. Roy's benefit. This is going to be a motion for summary judgment hearing in the matter of ICAFS Inc. Versus KP Painting LLC. The case number is 24CV008450. If I could get announcements for the parties who is here on behalf of the plaintiff.
Hey, Judge, that'd be me, Evan Beecham, and I represent, you were asking how to refer to them. I just call them ICAFs.
ICAP, that's much better. Thank you.
But it's ICAFs, the property owner, and a collection of insurance companies that underwrote the risk.
Okay. And Mr. Brown, you are representing KP Painting, is that correct?
Yes, Your Honor. Thank you.
It's good to see you, Mr. Brown.
Good to see you, Judge.
Okay, so as I mentioned, we are here on KP Painting's motion for summary judgment. There are some associated motions to strike experts, particularly Mr. Snyder and Mr. Gray, that are associated with the, they're sort of intertwined, I guess, with the motion for summary judgment, but I'm going to start by telling you the sort of bare bones of what I think I understand about y'all's case. And then I will hand it over to you, Mr. Brown, to make your argument regarding your summary judgment motion. So as I understand it, this case arose, this is a fire loss, a very large fire loss in an apartment complex. And there is an argument, which is the subject of the complaint by the plaintiffs, that KP Painting was supposed to use intumescent, I hope I'm pronouncing that correctly, paint product in certain areas of the apartment that either they did not, or they did not use the appropriate product, or something failed that did not cause the fire, did not contribute to the beginnings of the fire, but I believe the plaintiff's theory is that the alleged failure by KP Painting contributed to the extent of the fire or to the damages that were experienced in terms of how far it spread, etc. And in response, I have a motion for summary judgment from the defendants arguing that there is no dispute as to the causation of the fire, and that they are entitled to summary judgment in large part because the theory on which that the plaintiff, I think, is advancing is speculative and is based on speculation by potential experts. I say only potential because they've been identified as experts, they've been deposed, but they are subject to a current motion to suppress under Daubert. With that, Mr. Brown, I'm going to hand it over to you and say, you will not hurt my feelings if you tell me that anything I just said was wrong, and certainly that most of what I just said was incomplete, and educate me or correct me as necessary to understand the issue from your perspective. Go ahead, sir.
To the contrary, Your Honor, that was very impressive. could not have said it better. That is correct. Mr. Beauchamp and I have been communicating for the better part of the day, and through Mr. Beauchamp, he's been communicating with David Besho, who I know very well. He's a good guy. In fact, I've been working with that firm for 30 years, which helps. We have agreed upon how to proceed if the court would allow what I'm about to say.
Okay,
before I
lay
do
it on me,
that,
sir.
And it would include me filing today, after we finish, a withdrawal of the motion for summary judgment.
Okay.
But I want to show the judge two things just to add to clearly what you already know. And this is just to put in perspective our agreement. So let me see if I can do this. What do I hit now? Here it is. Okay.
Okay.
Your Honor, this is exhibit, for the record, this is exhibit 38 to the deposition of one of the experts, Dan Arnold, who I didn't file a motion pertaining to his testimony. And on here, I'm going to go to the third page, and this is just, I think it gives a good outline. It's a large complex, but the fire only pertains to this set of buildings here. And in compartment B, the fire originated on the balcony of Unit 19F. And Unit 19F is the second of 3 floors. So the fire started on the balcony, it went inside the unit, and going on the outside. So it's moving and growing in 2 different locations. My client had a contract and was required to, as the judge stated, to apply intromissive paint in the attic only. The attic is to the 3rd floor unit. So you have burning, and all the fire department people said if there's a fire, when they come, they're turning on their hoses. So you've got fire damage, burn damage, water damage, and smoke damage before it gets to the attic of the 3rd floor. It has to go through the 2nd floor and the 3rd floor. Is it sharing? Can you
Yes,
see
sir.
my
I'm
screen?
looking at somebody's discovery responses.
Yes. In the
Okay.
discovery response, we asked the question of the amount of your damages. And nope, I want to be clear that as I go through this, I don't think anyone did anything incorrect. It's early in the case at this point. This is the number that they had, $4,850,000. But that's a total number. Mr. Beauchamp and I and David Show agree that that number is not correct. It needs to be revised. So what we agreed earlier today, if the court agrees to this also, is we will dismiss our motion for summary judgment. We understand that we have some responsibility, and we're not going to shirk that. The plaintiffs will supplement their discovery response. They will revise this number to the extent they need to, and that's up to them. They will revise any expert reporting. And I will say, Your Honor, that one of the experts, Sean Gray, we haven't even taken his deposition yet.
Okay.
I had to meet this discovery deadline.
Mhm.
I had enough information, but this all works out well because they can go and talk to him and do any revisions that they need to work with him before we take his deposition, which we are in the process of setting up right now. We will report back to the court, or we offer to report back to the court in 4 weeks our progress. And once they revise this number, supplement discovery, I will dismiss the motions to strike Lucas Snyder and Sean Gray. And as I told Evan, I am not going to say they should revise it this way or that way. We just know that it needs to be revised. And at that point, it becomes a battle of the experts.
Mhm.
Let me see what else. So we ask that we hold off on the two Darbear motions, and we'll report back on progress in 4 weeks. And again, once they revise this, if it's before that 4 weeks, or if they need more time, but once they revise it, I will dismiss the motions to strike. Evan,
Oh.
if you want to add to that.
Yes, sir.
Yes, thank you. That is agreeable by the plaintiff. I would simply add at this early stage of discovery, as Ty pointed out, with the case in its infancy, we've not had the benefit of the consultation with our expert witnesses who prepared their expert report on damages. The tricky detail is determining the amount of damage the building would have sustained, irrespective of proper paint application. We will readily concede there is some amount of damage the building would have sustained anyway, had it been perfectly painted up to the standard of care. So I think we're largely, we may be totally in agreement on that, actually. I would suggest that the expert reports as written capture this level of detail pretty well already. One of our experts set forth a range that he believed the reconstruction, rebuild, and repair would have totaled at had the building been properly painted. But Ty is correct, this older discovery response does not identify that level of detail. It sets forth the total amount of the claim, which also is an estimate, as the insurer's adjustment had not been finalized at that time.
Mhm.
So we are perfectly willing to go back and supplement this response with updated information that is based on the relatively recently discovered information from our two experts who work together on this subject. We'll readily concede what Ty is getting at, that there is an amount of damage that would have occurred anyway, despite any issues relating to paint. So
Okay. So that all sounds fine. The only part that makes me laugh is y'all keep saying this case is in its infancy, and I'm looking at a 24 CV case number, which gives me the hives, but that's nothing to sneeze at. I mean, I understand that these cases are technical and complicated, and they involve a lot of lawyers and a lot of parties, which necessarily occasions some delay. So the only thing I'll add to that discussion is what you have outlined, Mr. Brown, and it sounds like Mr. Beecham is in agreement, works fine with me. My only question is, currently you guys are operating under your third amended scheduling order. Now, I gave you, because I know these cases can be complicated, I gave you guys in the amended one a giant window between dispositive motions and a mediation deadline. But technically your discovery deadline has already passed. And so what I wonder is if the party now, right now, you could adjust discovery schedules, and you still wouldn't necessarily be running into a pretrial that is currently on your third amended scheduling order for October. It doesn't sound like you're going to be ready for it in October. But my point is, it sounds to me like what you guys need is another amended scheduling order with some thought as to how soon you will be able to accomplish all of these things. Now, you don't have to do it immediately because, again, you're not about to run into any other deadlines, except the deadline to mediate is at the end of September. But it's the beginning of August. If Mr. Brown is going to, if this immediate issue is going to be wrapped up in the sense that, in 4 weeks, based on Mr. Brown's suggestion that we have sort of a 4-week check-in, and assuming there has been an amended discovery response by plaintiffs, then Mr. Brown would withdraw his motion for summary judgment and the motions to strike the 2 experts. He might, there would be no prejudice to his ability to bring them later, I guess, based on different issues, but the one that's, we're focused on now. But longer term, it seems to me like you guys do need to make some effort to submit an amended scheduling order.
So
Go ahead, Elvin.
yeah, I was going to say I fear I gave a misimpression about our level of comfort with the current scheduling order. We're pretty comfortable as the plaintiffs with the current scheduling order.
Okay.
We would like to see the case move along. When I speak about the infancy of the case, I think that's where the confusion arose. The discovery responses were prepared earlier in the case before the expert discovery had been done, that actually revealed the information about the difference in damages. And
Yeah.
that's what I think needs clarification. I apologize for presenting it in such a way. The plaintiff doesn't prefer additional postponements and moving of dates and deadlines. We are definitely we're trying to work with Ty as to this mediation, and that's more of a sidebar that we have going on. But that is simply what I wanted to say. I'm comfortable with the current scheduling order, would like to adhere to it if possible. And of course, we'll very quickly supplement the discovery responses that Ty has requested, and agree with his perspective on them.
Okay. Mr. Brown?
Your Honor, we are working well together, very, very well. And we've got several depositions. I mean, we're going to be wrapping them up.
Mhm. It sounds like I misunderstood, and that you guys are still targeting, right? Nothing's ever perfect, but still targeting a late September mediation with, preparing for trial if that's where this case goes sometime at the end of this year. And that's what your amended scheduling order says. I just, when you said infancy, wanted to check on that. Mr. Brown, I'm sorry I interrupted you. Go ahead.
No, that's fine. Frankly, I just wanted to introduce you to Christiana Luma. Sorry, Christiana, if I misspelled your last name. She's a bright young attorney at Copeland Stair, and she can address this issue. I'm just setting the tables. One thing that we wanted to be sensitive to is Corey Mendel, who's the partner that she's working with, is on maternity leave.
Mm-hmm.
And I'll let her take it from there.
Okay. Well, could you start by telling me the way your name is spelled on the screen? Is that an I-L or is it 2 L's?
It's I-L. It's
Okay.
Elena.
Okay.
Yes. Yeah, so Attorney Mendel, she's on maternity leave until August 17th.
Right. And I believe that that's where I recall now that the parties had asked for an accommodation. And I was like, listen, I understand being a working mom. I'm going to accommodate the maternity leave, but that some of the other accommodations that were requested were not affected by the maternity leave because we had already reached the end of discovery by the time she was going out, et cetera. And so that's why it's structured the way it's structured. And so it feels to me like what we are, what the position we're in, Miss Iluma, is that right?
Yes.
Okay. It feels like to me, the position that we're in, Miss Iluma, is that we will, it'll sort of stay the course now. And as you guys determine if you're able to conduct a meaningful mediation and then what arises from that and the resolution of today, right, with the additional discovery and the potential withdrawal of these pending motions, the only the only deadline that is a hard deadline that you'd have to go through me to move, right, is going to be this trial and pretrial deadline. And if you guys get to October and are not in a position to try the case, then y'all can let me know and we can talk about what that means and where it goes from there. I only opened that can of worms because it sounded like I heard a lot of discussion about the case being new, but it sounds like it's more advanced than I had realized. Ms. Aluma?
Yeah, no, I do agree with that, Your Honor.
Okay. Okay. Well, then we will leave well enough alone for today. Forget what I just said. And as I said, if the parties feel like that October is not going to be something they can accommodate, then y'all can come to me and let me know at that point. I will let you know that what will likely happen is that you guys will get a notice of trial and pretrial with your pretrial conference scheduled the week of October the 5th and your trial scheduled the week of October the 26th. And you will probably get that sometime in mid-September. So it'll be right before your mediation. And that will be the point at which y'all need to let me know, hey, we're ready or hey, we're not. Beyond that, it is August the 6th. What I will look for is something from the parties. September the 4th, which would be about 4 weeks from now, right before Labor Day, to let me know that the parties have consummated the negotiation agreement that they have today presented. And Mr. Brown will then, y'all can let me know by email, and then I'll just look for Mr. Brown to file something noticing that he has withdrawn those pending motions. Beyond that, is there anything that you guys need from me to keep your case moving along? Mr. Beecham?
No, Judge. I think that covers just about everything. Thank you for your time.
Mr. Brown?
No, Your Honor. Thank you very much.
Okay, excellent. Well, it was nice to meet you, Ms. Aluma. And I'm sure I will see you plenty of times again. And thank you all for your time. And I will see you guys in October.